Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss an important legal point. Whether permission is necessary to the CBI to arrest a joint secretary level officer and above or not according to Section 6A of the Delhi Special Police Establishment Act, that is CBI. We all know that CBI was established under the Delhi Special Police Enactment Act, that is Delhi 1946, Delhi Special Police Establishment Act 1946. They can investigate any matter entrusted to them by the central government. Of course, the permission of the state is necessary for them to investigate. Here the important point is the sanction from the center is necessary for investigating a case against the joint secretarial officer. But it so happened that the Kishore, R.R. Kishore, he was working as Chief Medical Officer in Delhi. He was arrested by the CBI when they trapped her. He was arrested while accepting the bribe. Right? He was arrested under Section 12 and 13 1D of the Prevention of Corruption Act 1988, and he was sent for remand. And he challenged the arrest, stating that Section 6A of the Prevention of Corruption Delhi Police Act needs the sanction from the competent authority to arrest a gazetted officer of the rank of Joint Secretary. So whether this will apply or not. So please remember, please read Section 6A Clause 1, Section 6A Clause 2 of the Delhi Special Police Establishment Act. You have to be very clear. Right. Now, the Delhi High Court, when approached by or when an appeal was filed by Mr. R.R. Kishore, Delhi Court specifically stated that 6.4a definitely will come as an impediment because the CBI has already started investigation and they arrested him. Therefore, they have to get permission from or sanction from the concerned authority. Agreed by this, Supreme Court, CBI filed a petition before the Honorable Supreme Court of India. Of course, it was referred to the Constitutional Bench. You know, Constitutional Bench means they contain 5 judges. So, under the head of Sanjay Kishan Kaul, I will tell you the names. Sanjay Kishan Kaul, Sanjeev Khanna, Abhay Srinivas Vakha, Vikram Nath, and J.K. Maheshwari. Actually, the judgment should have come in the last November itself. They have reserved the judgment. Almost after 8 or 9 months, they have delivered the judgment. A lot of discussions have gone. What happened is, in the meanwhile, please remember, in the meanwhile, in 2014, Subramanyam Swamy versus Director CBI, it clearly stated that Section 6.4a is held to be unconstitutional. Finish. And once it is held to be unconstitutional, it is void ab initio. That means it will affect. So there is a doubt whether it will be retrospective or prospective. So now the air is cleared by quoting Article 13 Clause 2 of the Constitution and its interpretation by authoritative pronouncements. So the bench stated that Section 6A of the Delhi Police Special Establishment Act is not in force from the date of its insertion, that is September 11, 2003. That means retrospective effect. So this is held to be void ab initio, non-est and unenforceable and stillborn as per Section Article 13 Clause 2 of the Constitution of India. Why? Why this stand was taken? This is what we have to learn from this case. So you can read the case as CBI versus Dr. R.R. Kishore. He was arrested in the year 2004. So he alleged that his arrest is not substantiated as there is no sanction from the competent authority. In the meanwhile, 2014 case has come. So 6A, now there is no 6A. Definitely CBI can file the charge sheet against him. But in 2018, another amendment, Section 17A was introduced. I think it is Section 17A. Very recently, yesterday, in the case of Chandrababu Naidu also, it was argued that the sanction from the governor is necessary. Please remember, Section 17A says orders for prosecution, they will be necessary from the governor or concerned President of India if he is the political or he is working under them. But when did this come? 2018. Our incident is 2004. In the meanwhile, in 2014, 6A was struck down. Now, whether 6A is there or not, this is the question. Definitely, 6A is held to be void ab initio. Then what about 2018 amendment? It came in 2018. This will not apply retrospectively. So, this is what is stated in the particular case. So, to sum up, I want to tell you, the Honorable Supreme Court of India stated that when once a section is held to be unconstitutional, then it is void ab initio, stillborn, non-est. Then you may get a question. What about Section 66A? We will discuss in 66A of the Information Technology Act 2000. It is also held unconstitutional in a very famous judgment of Shreya Singhal versus Union of India. Then what is to that case? Whether 66A is there or not. So, not recently, about 6 months back or so, Honorable Supreme Court of India chided the UP police officials to book cases under 66A, even though it was held unconstitutional. So, please remember, 66A is also not in force. Nobody can book cases against you under Section 66A of the Information Technology Act. Okay, with this I am concluding. Thank you very much.